There is a regulation whose discussion has been postponed and its approval has been delayed. That can change the internet as you know it and make it a less safe place for everyone, especially less safe for each of your personal freedoms. No, I'm not joking. No, I'm not exaggerating. Chat control is a regulatory nightmare which, like many other regulatory delusions, starts from a road paved with good intentions that, however, cannot work. And that you need to know about. I waited in vain for someone else to make an in-depth video on the topic, but I couldn't find any that satisfied me. So let's settle in here, take a deep breath, some time, and a cup of something good, and let's get started. Today, I will explain what chat control is, where it comes from, why it was proposed, what problems it attempts to prevent, and why, in reality, it means death, destruction, and total chaos for online freedoms. I am Matteo Flora. I have been working in this field for over a decade, especially in network monitoring. And this is Hello Internet. Hello Internet. Let's start from the beginning. Chat control is a proposal by the European Commission that basically obliges digital communication service providers, email, messaging, chat, and much more, as we will see, to automatically monitor all private communications for suspicious content related to child sexual exploitation material, XAMM. We need to specify once what XAM means. It stands for Child Sexual Exploitation Material, which is material related to the sexual exploitation of minors, including, but not limited to, child pornography. To avoid being demonetized, I will say the term child sexual exploitation material, XAMM. Every time you hear XAM, you know what it is. This monitoring must be carried out according to chat control on all communications, including those encrypted end-to-end. If they are encrypted, I can't do it. Through the scanning of these conversations when they reach the client level, meaning the sender and recipient on the user's devices. Why was it created? The proposal for chat control actually originates with a noble goal, which is to combat the spread of child sexual exploitation material online. This material includes many types of content, such as images, videos, texts, and videos that show sexual abuse of minors or even grooming, okay? The specific reasons why it is seen as necessary to implement chat control are first, the increase in XAMM cases. In recent years, there has indeed been a significant increase in cases of both sexual exploitation and the dissemination of material online, and European authorities are seeking much more effective methods to combat them. Then there is a part of crime prevention, of course. The main goal is to identify and stop the pedophiles and criminals who use online platforms to spread child sexual exploitation material, XAM, but not only that, also for another term, to lure minors, to groom minors, known as grooming in English. So if you hear me say XAM and grooming, you know what it means. XAM refers to child sexual exploitation material, while grooming refers to the act of luring and enticing. The third factor is the ineffectiveness of science of current measures, meaning the voluntary control measures implemented by various platforms are not considered and are objectively insufficient to combat the problem. The proposal therefore aims to make surveillance mandatory for all service providers, thereby increasing the coverage area, and the ability to detect material. And then, of course, there is the protection of minors, with the stated goal of protecting minors from sexual abuse and ensuring that any content that ends up online is promptly detected and removed. Let's talk for a moment about the regulatory context. The proposal fits into a much broader context of European legislation on data and takes security. It is part of the efforts that the European Commission is trying to make to build a safe and inclusive digital environment for everyone. For now, I still want to be nice and cuddly. The timeline doesn't come from just around the corner. It's a difficult and long path. It starts in 2020 when the European Commission proposed temporary legislation to allow chat control, thus permitting messaging service providers to voluntarily scan private communications. You say, wait, in what sense? Well, yes, because scanning, even just for suicide prevention, as it was done, is against the GDPR. So obviously, again, it was necessary to create an idea, a legislative platform that would allow even just searching. If you say, but why? Don't they remove, I don't know, but why don't they remove online scams when they are chatting and writing to me? Because providers did not have and do not have, due to encryption, but we see it elsewhere, the ability to see data. In data transit, a temporary approval of what is called Chat Control 1.0 was reached in July 2021 to allow voluntary monitoring of chats. What we are talking about now is Chat Control 2.0 on May 11th, I believe. Of 2022, the WANSA European Commission presented a proposal to make chat control mandatory for all service nature providers, no longer on a voluntary basis, etc. But this time it also includes end-to-end encrypted services. This proposal was developed, though there was a public consultation, and the public consultation showed significant opposition, which I will tell you about later, but it was enormous. Consider that. In that consultation, it is important to note that over 80% of the participants were against the mandatory requirement to use chat control, particularly on encrypted ones, those end-to-end. Not only in 2003, despite that, the European Parliament almost unanimously adopted a negotiating mandate to amend the draft law and try to protect the secrecy of digital communications and exclude the indiscriminate monitoring of these chats from now. This year, in January, the European Commission proposes a 2-year extension of the voluntary chat control, which is Chat Control 1.0. In February, trilogues between the Parliament, the Council and the European Commission begin to negotiate a final version. In March 2024, after a series of discussions among the members, seeking an agreement, they, more or less, reach a consensus. In June, the Presidency of the Council presented a report on the progress, and the ministers within the EU discussed the position and the proposal at this point to make this analysis mandatory in Chat Control 2.0. This week, Coreper, which is the Committee of Permanent Representatives, managed to adopt a position on the proposal, and there are attempts to approve it. However, even now, it is still pending. Jump, but with a danger, because in the next steps it is thought that we are waiting. Key 4-bit says it too. Who indeed shares my opinion? Let's see if I can do it. I need to see. What does Chat Control say? Here it is. According to Breyer, the supporters of Chat Control want to take advantage of the new European legislative period, which is the time during which the Parliament is in the process of being constituted, and therefore there is obviously less attention on these issues. Let's pause for a moment. Let me tell you what the chat control proposal says. Then I'll tell you all the problems I see with it. And we have to go into great detail, but I need to fix the camera because it's crooked. And it's bothering me a bit, actually quite a lot, because it's crooked. Oh, much better. No, too high. Now, let's start from the beginning. The main points, of chat control. I'm also looking at the notes. I have some notes, obviously. There are a bit too many. First, a point. Automatic surveillance. All communication service providers, including email, messaging, and chat, must automatically monitor all private communications to detect suspicious content related to the sexual exploitation of minors, including end-to-end encrypted services, that is, even communication services encrypted from one end to the other, where the data flow is encrypted, like WhatsApp, Telegram, Signal must implement surveillance. And you say, no, it's not possible because if it's encrypted, no. There is a moment when the data is not encrypted. When I see it, it's not encrypted. So on my device, before being sent somewhere else and after it has arrived and shows it to me, at that point the data is no longer encrypted. Therefore, providers are obliged to modify their clients, to modify Telegram, WhatsApp, etc., to turn them into a system that spies on the content sent and received, to check that it is not child sexual exploitation material. Not only that, it also integrates a whole series of important mandatory network blocking functionalities, meaning it introduces the obligation to implement network blocking systems to prevent access to illegal content hosted outside the EU, through URL blocking techniques similar to what is done for intellectual property for these types of services. Amidst all this, there is also age verification. The implementation of age verification systems is required for access and some communication services and applications to prevent minors from entering potentially dangerous platforms. But Matteo, but is it already there? Yes, not at the European level. Certain things change in different parts, and it doesn't work. The systems that exist now, more or less voluntary, do not work. There's no point beating around the bush. Come on. Another interesting thing is the censorship of app stores. That is, app stores must verify the age of users, prevent minors from accessing certain applications, etc., and those considered at risk of grooming, meaning at risk of enticement, and other forms of abuse. Another fundamental point is that this obligation extends to providers outside the European Union who, if they still want to reach users in Europe, must comply with the regulation. The other part that changes between 1 and 2 is the extension of the control to hosting services, meaning all hosting services, including web hosting, social media, video streaming services, file hosting, cloud services, etc., are included this time in the regulation. So they also have to monitor the uploaded content. Then there is the obligation of reporting and notifications. Reports of suspicious content must be transmitted to the authorities, and in many cases directly to the police, without the need for preliminary human review. So everything that in theory could be that type of content is sent directly to the police. A bit like how it actually works with hashes in the United States, with the American NMAC, obviously, and if providers become aware of clearly illegal material, say, they must remove it promptly, and that's it. There is a general obligation for security measures, meaning they must implement effective security measures to prevent misuse by minors, such as the ability to block users, moderate high-risk public chats, etc. This is basically the complete architecture of everything we discussed. I imagine your hair is already standing on end, but if not, take a deep breath and let's look at all the issues of mass control, of controlling the masses, and let's start from the beginning. Mass surveillance, okay? A big family of privacy violations. Mass surveillance. It's useless to say no. The proposal necessarily implies mass surveillance of the private communications of all citizens, regardless of whether there is a concrete suspicion or not. Okay? In any case, that's it. Regardless of whether there is a suspicion, because wiretaps exist, for heaven's sake, absolutely yes, but they are done based on a principle where they are applied, where there is a suspicion. Here, we are all suspects and all under surveillance, regardless of what we do. And you don't need to be a top-notch jurist to understand that this represents a fundamental violation of the right to privacy and the confidentiality of communications. In practice, it means the end of the confidentiality of communications, even if it is done by an automated system. We can discuss it further later. Not only that, but in practice, as we mentioned earlier, client-side scanning of encrypted messages, those encrypted end-to-end, means that every device will essentially become a surveillance tool. At the moment, it is obviously set to monitor only CSAM, but it will be ready to surveil anything else. And in many cases, where the operators, the programmers of these individual devices and these individual clients can be effectively forced to implement other surveillance systems on top of the existing one because it is already in place. All of this, in the absence, and I would like you to stop for a second and think about it for a second, in the total absence of judicial oversight, that is, the monitoring and automatic assignment occur without the need for a judge's warrant, and this contravenes many fundamental principles of justice which rightly require judicial supervision and approval for the surveillance of private communications, which here instead become automatic. Another major category is the focus on effectiveness and false positives. That is, we know that the algorithms used to detect CSAM are known for generating a high number of false positives. For example, there was a test conducted by the federal police, it should be Switzerland, which reported that 80% of the content flagged by the exam systems is not criminally relevant. I mean, a photo of my daughter, of my half-naked niece, is content involving a minor, but it is not criminally relevant. Okay, especially if I send it, I don't spread it online, but send it to her dad. If my sister sends me a picture of my niece in dishabili, okay, because she sends me a picture of her while she was changing her diaper and had just washed her, okay, which she doesn't actually do because Christina turned out well, but let's leave that aside. Even if she did, it wouldn't be criminally relevant. Okay, and the reports of false positives include vacation photos, children at the beach, and more. I often remember a case from not too long ago. The children are not naked. It's simply a photo of a child in a normal swimsuit. But the swimsuit is not perfectly visible. If you look closely, you can see it, but at first glance, due to the color and so on, it seems like the child isn't wearing it. All these things are sent, which means an enormous, exaggerated amount of reports generated by automatic surveillance systems that go to law enforcement. Okay, 1, by overloading them. Okay, 2, by diverting a whole range of resources that should be focused on real, targeted, significant investigations, which, actually, risks reducing the overall effectiveness in the fight against true child sexual exploitation. Then there is another vast world of implications, which are those for actual security, starting from the compromise of encryption, that is, to allow the scanning of encrypted messages. It would often be necessary to introduce a vulnerability or multiple vulnerabilities into the encryption systems, which in this way compromises the security of communication, not only for the wrongdoers, but for all users. All these vulnerabilities can certainly be exploited by law enforcement. But they are vulnerabilities. If there's one thing we've understood, it's that if law enforcement can exploit a vulnerability, the same. Vulnerability will be found by criminals, authoritarian governments, etc., and it will be misused. Okay. Zuboff's second law states that any gonbone technology that can be used for control and surveillance will be used for control and surveillance. And then the precedent. Okay. I mean, I was telling you earlier when I said that those who write clients, etc., can then be compelled. The introduction of automatic surveillance technologies sets a precedent, and sets a precedent, in this case, for intrusions into digital privacy. These technologies could, and often do, be used in the future for other purposes, such as monitoring political, religious, and, quote, ideological content. I'll pause for a moment. In authoritarian contexts, okay, where these things are considered crimes, on par with explicit sexual content involving minors, on par with CSAM, I don't see why. Governments shouldn't also require monitoring of those contents, since they are already doing the rest. And in authoritarian contexts, these tools can be used and would be used to identify and suppress whom pedophiles know, political dissidents, human rights activists, journalists, etc. Yes, because the other major macro category is the impact on human rights and freedom war of Cohen expression, starting with the minors themselves. So should minors who share intimate content, who engage in sexting, be criminalized? I might agree, but let's think carefully, because statistics show that a significant portion, for example, in Germany, of investigations into child pornography involves minors themselves, meaning they voluntarily shared these contents, and in this case, they would become stigmatized and prosecuted criminally, and this can only have a devastating impact on the lives of young people, on their future, on their reputation, right? And then there's the whole world of safe spaces, you know. I mean, victims of sexual abuse need safe spaces to communicate with counselors, therapists, and other victims. The surveillance of communications can discourage them from seeking help, reducing possibilities of support, recovery, and trust. Perhaps it is not clear, but trust in the fact that communications would remain. Confidential trust, in general, towards the world of communication. Confidentiality is essential for those who report abuses, perhaps even by actions committed by members of the police, and in this case, their report of the abuse would be referred back to the police, and a loss of trust can inhibit reporting and ethical support from many. And lastly, although it's not really my area, let's have a discussion about the final major issue, the ethical and justice problems, because here we are basically talking about a sort of privatization of justice. Let me explain why. The proposal delegates to large tech companies the task of deciding which content to flag as suspicious. This transfer is a transfer of responsibility from judicial authorities to private entities that, however, have a different degree of tracing and transparency and a different degree of accountability. The algorithms used for monitoring are not subject to public oversight. It means that citizens, for example, have no way of knowing how these decisions are made, and most importantly, have no way to contest any errors, deletions, or blocks. Surveillance algorithms can reflect and amplify, as we now know, existing biases in the training data, etc. Especially when these decisions are used to determine whether a profile is safe or not. For instance, my little sister's profile, which she uses to message me, might become less safe for other reasons. And let's remember that wherever there is, indeed always, a surveillance system, there are people who manage these surveillance systems, and the workers of the tech companies that manage the surveillance systems could, and it has often happened, as we have seen, in almost all cases, abuse their access. Not so much to assign access, but their access to private communications, and it has already happened with cases of stalking, abuse of power, etc., and we know. It has already happened. We have practical evidence. So, to wrap up, also because I think we're at 26 minutes, if you've made it this far, you're absolute heroes. And today's word is drone. Okay. Write it down below, and while you're at it, subscribe to the channel because we need to reach 100,000. Making videos like this is complex, and it's already midnight. Give me a hand. Come on, as I was saying. Conclusions. I am the first to say that the proposal for chat control is motivated by noble intentions to come protect minors. And not only that, I am the first to say that it is necessary to find some solution, because at this moment there are no effective solutions to prevent a whole series of issues related to content that is being reshared, not only of minors, but also of sexting. And more than anything, I would say non-consensual pornography, etc. I am the first to say it, but in formulations of this type and with this breadth, chat control presents too many critical issues that could have serious and devastating consequences on privacy, security, human rights, and freedom of expression. The technical solutions proposed within strongly risk compromising trust in digital communications, the overload of law enforcement, and the introduction of vulnerabilities in systems that we have strived to make secure, which now become vulnerable by design. And this is wrong. A more balanced approach is needed, one that perhaps includes strengthening investigative capabilities. Okay, but that also maintains the protection of fundamental rights. It would be desirable to indeed effectively address the problem of pedophiles every once in a while, without heavily and significantly sacrificing all civil liberties on this altar, because in a just world, I am truly and absolutely willing to sacrifice quite a bit of my civil liberties to combat these phenomena. But since we don't live in a just world, I'm not willing to give them up. Why? Because the designed infrastructure delegates powers over my civil liberties to private companies in contexts that have nothing to do with that part of child sexual abuse material too. Many powers. Too many risks, which I am not willing to tolerate, especially for a system that has an 80% false negative rate. Now, what do you need to do? Just simply know it. Listen, follow the various parts. If you are people who can speak up at the level of an tech policy, say your piece, say that it is not working. Join advocacy groups, Privacy International, EDRI, us at Hermes. There are many, but basically knowing it and not ensuring that it gets applied is just so. Because no one said anything, which is the thing that scares me the most of all. There is a cartoon that made me laugh. But also think, let's put it this way. I don't remember where I got it from. It might be political, but I don't remember. I have to tell the truth, which is this. But shouldn't we be looking for sexual crimes and terrorism? No, don't worry. That was. In the previous legislature, and always remember the phrase we often chat about. Those who are always willing to sacrifice their freedom for a bit of temporary security will have neither, and perhaps do not deserve either. Indeed, that's it. I would say we're done. Tell me a bit about what you think in the comments below. And with that, share this video. This time I'm asking you, usually I almost never ask you as you've seen, but if you subscribe, share this video. With what you've taken, with your comments, adding what I might have forgotten, in between, excuse me, it's late, but I really wanted to do it. Adding your point of view, absolutely yes, but it's absolutely necessary. This time, more than many others. And as always, thank you very much for listening to me, and be prepared.